Hi everyone, this is Jyotsna. Welcome to Frontlist Spotlight session. So today we have Ms. Priya Rao and Aprajita Nigam for our special Name Month Spotlight session. We are immensely glad to have you both of you on board today. So welcome.
Thank you.
Thank you, Jyotsna. I'm really glad to be here. Thank you for the invitation.
Pleasure to be here.
Okay, thank you so much. So today's spotlight topic is challenges of copyright in a digital age. So before delving into the session, allow me to introduce you the panelists of today's panelists. So first, we have Priya Rao. So Ms. Priya Rao is the founder of Priya Rao and Associates. For the last 2 decades, she has advised and represented several Fortune 500 companies in India and internationally. In a career of over 23 years, she has handled several matters including company law, tax law, anti-dumping law, intellectual property, family law, arbitration law, and writ petitions for clients across the globe. She has also specialized in IP since 1999. Over the years, she has handled all the aspects of prosecution and enforcement of trademarks, copyrights, geographical indications, and design. She has expertise in conducting civil and criminal raids connected with anti counterfeiting and anti piracy initiatives on behalf of clients in electronics, automobiles, FMCG, software, luxury goods and garments, foods and beverages, the publishing industry, etc. She also specializes in IP strategies and large size trademark portfolio management. She has advised clients on transactional issues, including IPR, due diligence, acquisitions, and IP valuation. She is also served as a member of Anti-Counterfeiting Committee of International Trademark INTA for the 2020-21 term. So you've already served it, right?
Yes.
Okay. So next on panel, we have Ms. Aprajita Nigam. Aprajita Nigam is an advocate enrolled with the Bar Council of Delhi since 2013. Having started her career in criminal litigation, she gradually moved she gradually moved towards IT specialization. Ms. Nigam holds an LLM in IT rights from NLSAR University of Law, where she earned a gold medal. She has also completed an executive program in MA Law and a certificate course in the Korean language. Ms. Nigam has thorough understanding of IP law and is particularly interested in niche and specialized areas. She is a managing associate at LexOrbis, where she handles trademarks and copyright matters, prosecution, contentious and non-contentious, and domain name complaints, as well as drafting privacy policies, terms of agreement, and opinions for complaint procedure. She regularly attends hearings at the trademark office, represents the firms at prestigious conferences. She handles diverse client portfolio comprising various Fortune 500 companies, multinational corporations, small and medium-sized enterprises, media entertainment companies, pharma companies, technology startups. So welcome both of you today on the panel. It was quite a long introduction, I must say. So welcome.
Thank you. Thank you.
Yeah. So our topic for today's spotlight session is challenges of copyright in digital age. So today we'll be talking about challenges with the advent of digital age and how is it impacting our publishing industry and the rights of the creators. Okay. So my first question to both of you: the challenge of copyright in a digital age is the ease with which works can be copied and shared without permission. So it's like free will, people have free will to copy. But how can creators and right holders protect their works from unauthorized copying? So I would like to start with Ms. Priya Rao. So.
Yeah, hi. So I think it's an interesting time, digital age. It has made businesses work from home, because it's a digital age. Unheard of things is possible today. So with ease of doing work, with ease of making creative contents, it was never heard of that you can make musical work and put it on YouTube, and it's so easy today. So with the ease with which digital age has given opportunity to creators, it's in the same way it has made copying also very, very easy. So in my humble opinion, that a creator, basically whoever is creating his or her work, should first and foremost, thumb rule. It's an advice across, will be that whenever you create a work, make sure that you protect it under the Copyright Act by registering it. It's a very, very simple procedure. It is not expensive. It's very, very simple and very fast. So my advice to a creator and right holder of work is, first, whenever you create your work, go and protect it. Systems are available, again, digital age. It's available online. You can file it yourself. And the second mechanism that one should also use once you have created your work, be vigilant. Vigilance is another thumb rule. So you use, there are systems and technologies in place, like digital rights management system that is available. Technologies are available whereby you can actually track your infringement of contents online. The other tool that you could use to kind of protect copying of your work is watermarking your content. So there is visible watermarking, there is invisible watermarking in your work. So if you have created a website, or you've created a published work, you've created a novel, or you've created an article, you identify yourself as the owner of that particular work by visible, saying that, you put your C in a circle and tell the world that I am the owner of that copyright. So that is watermarking, which is visible watermarking. There is also invisible watermarking. If somebody copies your content, you can track the infringement. Similarly, another easy and cheap tool which you can use is that, licensing agreements. You can always provide licenses where you want to, it's a good way of monetizing your work as well. You give them limited licensing, right? Okay. So that is another tool that you can use. And lastly, by being vigilant, I would also say that not just identifying if somebody is infringing your copyright work, just sleep over it. You can't do that. In fact, you should be spontaneous, immediate, and address takedown notices to these infringers. So because it's a digital age, it's a quick, the number of people who can have access to your content is very fast. And if somebody is infringing your copyright, the access is so rampant that, you have to immediately work towards it. Therefore, you'll need to address it by a takedown notice. So have a good takedown policies also.
So, Ms. Priya, does it involve any cost to copyright your work, or is just a free if someone would like to copyright your work?
So, see, to register a copyright, you can always go to the copyright office, which is available online. The fees for registering a copyright is very nominal. It's 500 rupees. And there are the forms. It's a very easy to use platform also, where you can download the forms, fill the form, and upload the form, pay the fees. And it's that cheap, I can say. If you do it yourself, it may cost you 500 rupees. But if you can also use a lawyer who is in this area of practice in the IP sphere, will be always available for filing. Even for that matter, a copyright application for protecting and registering the copyright, it's not very expensive. Even lawyers don't charge an hefty amount, because we all understand, how creative world is, and try and keep the costs low.
Thank you so much. So moving ahead, Ms. Aparajita, your take.
Yes, see, mostly a lot of points have been covered by Priya, but as she said, that registration is extremely important. Though it's not mandatory when it comes to copyright, copyright comes into existence as soon as you create your work. But if you ask any lawyer, any attorney, they would tell you that registration really helps because when you're going to enforce your right, that acts as a proof of ownership in your favor. So registration is very important, and she also mentioned that it's not expensive. It's very nominal, 500. As she mentioned, it's mostly 500 for all musical, dramatic, literary works. If you have sound recording, it's just 2,000 rupees, and for cinematograph films, it's 5,000. So in any way, it's still from 500 to 5,000 is the official fee that differs. And attorneys also don't charge much for it. It only takes 2 to 3 months for your copyright to be granted and the certificate to be issued to you. The other thing I think, even before registration, which a creator should always look after is proper documentation. Whenever you're creating a work, for example, you start to write something today and you have made a half draft of it or a first draft of it, save it with a date stamp in your system or email it to yourself or, email it to some software so that you always have a date creation in your favor. So tomorrow, if someone, you are involved in some suit and someone says that they created the work before you can always show your date creation. Whatever documentation, whatever drafts are being made towards the final draft, save all of them with a date stamp. The other thing you must remember is that in case you are an organization and you are hiring someone else to make something for you, in case of any kind of independent contractor creating a work for you, always remember to have an IP assignment clause in the agreement that you are making with them. Because in case of your own employees, the law can help you because in case something is created by an employee in the course of employment, then by law, the organization and the employer is the rights owner. But that doesn't happen in case of an independent contractor when you're hiring another organization or someone else who's not an employee with you. So always have that kind of an IP assignment clause in the agreements, and also, if possible, get an NOC executed, because when you tomorrow go to get a copyright registered, they ask for an NOC also, which is there in the rules. So along with the IP assignment, get an NOC executed so that you can get your registration easily. And apart from that, you can always, whenever if your work is available online, make use of access controls and copy control software. So if you must have seen it on a lot of websites, if you go and you want to copy the content, you aren't able to do that. It is because of the access control and copy control software. So use that. You have blockchain technology these days that can really help you have a database of your works, also see that what kind of downloads are happening. It also helps you have a database of your date creations. So all these new technologies coming up can be used by a creator to have a proper documentation in place when it comes to their any kind of work that they have created, because ultimately what is to be proven is your ownership on the work and your date of creation and originality. So anything that helps you protect these three things, you should keep that in mind.
Thank you so much, both of you, for explaining it in a detailed manner. So moving ahead, my next question. How do you see copyright law evolving in the digital age, and what role can policymakers and stakeholders play in shaping this evolution? So I would like to start with Aprajita Nagam. So yeah, move ahead.
Yeah, see, with the whole digital age, there are so many things changing, and we still require a lot to be done when it comes to the law. And I think the first thing that comes to my mind is that you're talking about the creators or the policymakers? The the policymakers. Okay. So see, the first thing that comes to my mind is there is this debate around AI generated works that is there, because nowadays not everything is created by a human. It can be created by AI. So we still don't have anything any laid down law regarding this, because recently, about 2 years back, one of the application that was filed in the copyright office regarding, there is an app called a Raghav app, which was AI created. So first it was refused because the sole author was named as the AI. Later on, the AI was named as the co-author along with a human author. That time it got registered, but later on, Copyright Office then went back and issued a withdrawal notice for it. So what happens to AI generated works is still not clear. So some final, some amendment needs to be made in the act so that we are clear on that position. Apart from AI, the other thing which has been going on when it comes to our country has been the issue regarding statutory licensing with respect to internet broadcasts. Because what we have right now in our rules and in our act regarding statutory licensing is for radio and television broadcasting. So we need something on that front for a clear law to be laid down. So some changes to be made, not just in the rules, but also in the act, so that each mode of broadcast is included when it comes to statutory licensing. So I think that AI, we need some clarity on the AI generated works, as well as all modes of broadcasting must be included in the act.
Thank you so much. So moving ahead, Miss Priya, what's your take on this?
So I think Aparajita has very well summed it up. I think, these are the two areas, according to me, that really requires, still there is a lot of ambiguity as to what happens, who is the owner. Because IP, when it comes to IP, it's very important to define who's the owner. Now, there is no clarity on that when it comes to AI. So that's one area. But having said that, I think copyright law is the law is always evolving. So as things in the digital age keeps developing and progressing, we keep seeing a lot of development, not just in the copyright area, but in fact in the information technology side also, because digital area is squarely covered also under the information technology law. So we've seen because an information technology law has been amending as things have been evolving. So we've seen a lot of changes in this area since 2012. Even copyright law since the last amendment in 2012 actually dealt with the digital era, and made some amendments which took care of the digital era. The work which is on in the internet space, in the digital space. Similarly, under the Information Technology Act, there has been a lot of development, specifically in the intermediary space as well. So we've seen a lot of changes there. So there has been a lot of changes we've seen there. Having said that, also one area I think policymakers, perhaps, in my view, because I'm also an enforcement lawyer, because now everything is so easily available online, in the e-space, on the internet. The breach is so rampant. The penalty clause, when there is a violation, the provisions, it has to be more stringent. The penalties, the imprisonment, you have to extend it. There has to be a provision which makes any infringement of any copyright work, to be, very stringent. It should be a non-bailable offense. I think, in fact, the industry in general has been talking about it, and it is time that we do that, because otherwise, they just pull down, take down notices, intermediary just takes it down, and nothing happens after that. They come back in another form. So there has to be a fear. There has to be such provisions. That's my 2 bits on it. Thank you.
So do you guys want to add more something to about AI aspect? Because I have another question for the AI, but I don't want to repeat it since we are covering it here.
Uh, so see, for the AI thing, I think what I'd say is that we would require amendments at a lot of places. First, we will have to amend the definition of how we define an author so that it can include as authors something that is created by an AI. That would also require changes in, say, when we talk about the ownership. Where does the ownership go? So, if you are recognizing AI as the author, we understand that, but who's going to be the owner of that work which is created? Is it going to be the person who's in control of that AI, or something that has to be included there? The other thing that would have to be changed is term of protection, because in copyright, the term of protection in a lot of works is seen from the life of author plus 60 years beyond death. So if you are saying that the author is an AI, then how do you define death of AI, right? So that has to be something like how we have in sound recordings or in cinematograph films, which is 60 years from the publication date. So something like that has to come up in cases of work that is created by AI, that it could be 60 years from publication date or whenever it was, put in for use. So term of protection, ownership, definition of authorship, a lot has to be changed when it comes to AI generated works.
Thank you so much. So Priya ma'am, anything else you would like to add?
No, I think there is a lot of ambiguity here. It's not going to be very easy. That reminds me of this monkey case where, there was this monkey who snatched a photographer's camera and clicked his own selfie. So, who is the owner was a big issue that became a huge, photograph. Everybody was talking about it. So that was a big, huge debate. Now we have, this new monkey AI.
Yeah, absolutely. But yeah, we surely figure it out.
Yeah, gradually.
Yeah. So my next question, both of you. Some have argued that the copyright law is overly restricted and inhibits innovation and creativity. How can we strike a balance between protecting copyright and promoting innovation? So I would like to start with Ms. Priya.
I think it's the striking a balance between copyright and promoting innovation is a complex issue, no doubt. Some of the ways where we can actually promote innovations are by, I feel that there should be more encouragement of open sources. You should have more so that people can use open source to create something more creative based on that. So I think we should encourage use of open source software, and encourage Creative Commons, whereby you actually hold your ownership, but at the same time you can encourage people to use your work. Similarly, I would say that, to strike a balance for promoting innovation is by having a fair use policy where you can clearly define, the law clearly defines, there is a definition to fair use under the Copyright Act, but there has been always a lot of ambiguity around it. So if there is a lot of clarity as to what fair use is in this new digital age, I think that would also promote innovations. Also, I would say that encouraging education, educating people from not stealing anybody's copyright work, violating. I think education is very important. We have to promote, talk about what is ethical and what is not ethical, because, the speed with which the creativity is made, the speed with which it has reached. I think it is more important also to educate in this space. So that's my few points on this.
Okay, so thank you. So moving ahead, Aprajita, your take on.
Yes, so as mostly Priya has covered it, but see, the Copyright Act, when it came into existence, when the concept of copyright came into existence back from the era of Statute of Anne, it came to incentivize and actually promote innovation so that you incentivize the authors and they are motivated to create more. But now, yes, there is a debate that are we going overly restrictive with the copyright, and is it sort of, hampering the very purpose with which copyright was created? I'd say that while some people may say that it's a very restrictive law, I do have my reservations on that, because even if it is very restrictive in nature, just see the level of infringement that is happening. It is everywhere. Infringement is still happening even if it's a restrictive law. So, but yes, when it comes to promoting innovation, promoting creativity, we must have a proper check, in the sense that we must have a proper definition when it comes to fair use. Because, if you see in the space of entertainment, especially, you see, you see on Instagram fans creating these very beautiful video mixes of their favorite shows, of their favorite movies, students writing fan fictions on the basis of their favorite novels. So there's a lot of derivative work, a lot of transformative work that gets created. And to be honest, if you read them, because I have been a Harry Potter fan when I was a kid, and I used to read all fan fictions, and as much as I can say that all they were inspired and derivative works from what J.K. Rowling wrote, but those students, those young creators, had written something very beautiful fan fictions. So we must, think on those perspectives also, that how can we, make copyright law in a manner where it is not just restricting, it is incentivizing the authors in one way, but it is also allowing others to use that work in certain ways, so to create more, more works. Anyone stands on the shoulders of the giants, right? Most of the work that is being created. So we must allow that. And as Priya ma'am mentioned about Creative Commons, you have various kind of licenses there, where, like CC BY license or a CC BY share alike license. There are many licenses where, if someone wants to give those license, and this is how the works can be utilized by others, and so that, more derivative works can be created. That is a good way to promote creativity, along with protecting your work and making sure that it is used in an authorized and licensed manner. So that is, I think, one of the ways in which we can create a balance between both. Yeah.
Okay, thank you so much. So my next question. So it's for Priya ma'am. Okay. So as a founder of Priya Rao Associates, you have worked with creators and rights. And what strategies have you found the most effective? And what advice do you have for the creators looking to protect their works online?
So some of the tips that I actually, I give my creative group, the people who I work with, authors or some on the media side, my thumb rule and the very fundamental and the very basic is that when you create a work, of course, like Aprajita said, create your record. Have the evidence as to when you created it, email it to yourself, have your dates on it, and first and foremost, register it. It takes no effort, but it takes you miles. It protects you from any kind of infringement, and it's also a documentary title for enforcement. If any violation happens, that's a basic document that we use to show that we are the owner. And of course, if there is any dispute on it, that's a matter of court and evidence. But having said that, the first strategy is always, please protect your work, register it, keep evidence that is you're the owner. Second is, of course, before you share your, your work with because a copyright owner would want to exploit it. So before you share it with any publishing house or media, any agency, get into an NDA with them, and an ownership, the agreement that you are sharing this document, and it's only for their eyes and only for the purposes they acknowledge that you're the owner of it. So this basic agreements have to be in place before you share any of your work with any agency. So that's the second point. So because you have to be careful. So that is the second strategy that I always advise my clients. And the third is, of course, if you're putting your work on the internet, or if it is being shared, you have to have monitoring systems in place. You should have, like I said in the initial bit, that have watermarking, have digital right management technologies in place. Have that in place. Be vigilant. It's your hard work. Don't let it just go into the public domain. That is one. And if there is any infringement, then you have to be extremely vigilant and serve them notices. Takedown notices is something which you will have to take actions and take steps towards. In case you can't do it yourself, of course, the lawyers are always there. But if you see that there is an infringement, is wrong use of your work, please immediately take steps to have it pulled down. And these days, social media is also very cooperative because of the IT rules. The moment you receive a complaint from any of the right owner, as per the intermediary rule, within 36 hours, they have to act upon it and pull it down. Otherwise, the safe harbor is taken away. So they are also aware of what consequences will follow in case the infringement work has not been pulled down from the internet. So these are few tips that I do share with my clients.
Thank you so much. So my next question for Aprajita. So with the rise of the digital age, how do you think the copyright laws have adapted to protect intellectual property in the online sphere?
When it comes to the digital era, I think the amendment that came in 2012, we started to think about the digital era since then. So with the introduction of section 65A and D were specifically included in Copyright Act back in 2012 for digital rights management. But apart from that, we are yet to see, as I say, that related to AI, related to internet broadcasting, we are yet to see amendments in the Act. But there have been developments in this space coming through the court. So when it comes to the digital era, I think John Doe orders can have been really helping. BCCI, in fact, uses it often. ICC used it in 2019 before the Men's World Cup. So in John Doe orders, what you have is that in case it's a large scale infringement you're talking about, and you're not sure about how many defendants are going to be there, and the dependents are unknown, because when you're broadcasting something, if it's some kind of World Cup happening, IPL happening, a lot of people start to broadcast the same. So John Doe orders can be used to secure injunction against unknown parties as well, so that one injunction can apply to all. Then recently, the courts also came up with the concept of dynamic injunctions, where if you have secured an injunction against a particular website which has been hosting some kind of infringing content, and a lot of times what happens is that you secure an injunction against one website, 5 days later, with some alphanumeric change or something, a different website comes up, it is redirected to a different domain. So in such cases, this dynamic injunction can be used. So if you have already secured an injunction, Then later on, and if you find another website with just an alphanumeric change hosting the same kind of content, you just need to, add an affidavit to it, and you don't have to go to the court. You can approach the registrar, and the same injunction will be applied on the other website as well. So these are the things that have come up, and John Doe orders, dynamic injunctions, they can really help in cases of copyright infringement in the digital era. But as far as the act is concerned, we're yet to see more amendments in it.
Thank you so much. So now we are running short on time, but before winding up the session, I would like to know your closing remarks. So if you have any, please share with the audience. So yeah, Priya ma'am.
So thank you. It was very interesting questions. I must compliment you for these interesting questions. And my closing remark would be like, the Indian legal system and the laws of the copyright law or IT law, particularly both I closely work on, I feel it's very robust, and it's very international. Of course, law has to keep evolving. We do see issues, and thankfully, we don't see any reluctance in the judiciary or in the parliament to not revise or amend if there is requirement for the same. So I would say that certain aspects, particularly, for example, like I said, on the copyright law, because there's so much of rampant infringement happening. I think one area which needs immediate, which is achievable, there's no ambiguity on that, to kind of strengthen the provisions of the penalty and imprisonment, so that there is a lot of fear when somebody infringes anybody's hard work, and there is a consequential jail to it, because earlier Copyright Act was meant to make the offenses non-bailable, but now with some interpretations of court, it has been interpreted that it's bailable, though it is you don't need a warrant for arresting anybody. It's cognizable offense. So a closing remark would be that if that can be improvised, then things will be more better.
So Ms. Abrajita.
Yes, so I think in my experience, one area where I have faced a challenge is that while we are coming up with takedown policies, we still need to come up with a stay down policy, and especially when it comes to copyright. So just to give you an example of a recent issue that we were dealing with. So there is this very famous engineering institute in India, and one of the alumni created a page on a social media platform, and people started to take that page as the official page, and that garnered more than 30,000 followers. And we had to get that page taken down. Now, the challenge was that the logo which he was using as the profile picture, that logo, the institute had not got registered as a trademark. So we thought that, we'll file an application, let this be registered as a trademark, and let's try and get this down by using it as a fake page, and, by putting copyright infringement, because logos are a subject matter of trademark as well as copyright. But while on the basis of a trademark infringement, you can take down an entire page, with copyright, what happens is that they will only take down the content and not the entire page, only the infringing content. So what the platform would do, that it would remove the profile picture where the logo was displayed, but then 2 days later, the person would upload it again. So while takedown was happening, the stay down wasn't happening. But luckily, in this process, we got the trademark registered. So we filed a trademark infringement complaint, and then the page was taken down. So this is a challenge which is coming with respect to copyright, that we need something that, if there is something which is going continuous infringement, then something like a stay down or taking off the entire page should come up with the policies of the intermediaries. So this is also something that we need to look forward.
Thank you. So thank you so much for coming today, joining us, discussing about the copyright in digital age. I hope that the audience also enjoyed this session and I've learned a lot. I got to know new things in the field of copyright and in the publishing industry as well. So I'm hoping that this conversation will, bring a new change, or maybe people get familiar about the some details about the copyright in digital age. So thank you so much, and it was lovely session with you. Thank you, both of you.
Thank you.
Thank you, Jyotsna. Thank you.
Thank you, and have a good day. Yeah.
Thank you so much.